According to our revised Evidence Act, every person or every individual is competent to give evidence in court. Every person is competent to give evidence in court. Section 117 of the Evidence Act is to the effect that every person is competent to give evidence in court. But who is this person giving evidence? In law of evidence, we call that person a witness. Who is a witness? According to the case of R versus Campbell, the court held that a witness is a person who testifies in oath in courts of law. That person who is able to testify in oath, given that in court we testify on an oath, that person who is able to testify in oath, that is the one that is known as a witness. And section 117 is to the effect that all persons, regardless of what, they are all competent to testify in the courts of law. That is the general rule. However, when you talk about competence and the comparability of witness, who is a competent witness and who is a comparable who is a comparable witness? A competent witness is that person who has the capacity to testify in the courts of law. The person who has the capacity, the audacity to testify in the courts of law. That one becomes what we call a competent witness. It means that that person, according to the section 117, that person who has the audacity to answer the questions being asked to him and bring answers with rational answers, becomes a competent witness in the courts of law. However, let's dive and we understand this. Whether we have other types of witness, because the general rule is saying that all persons, they are competent to give evidence in courts of law. However, the minors are also competent to give evidence in the courts of law. What about the dumb witness? What about the spouses? Are they competent to give evidence in the courts of law? Let's dive into this. Let's talk about competence of a dumb witness. The general rule in this is that dumb witnesses or the dumbness or dumb witness, these ones does not render a witness, dumbness does not render a witness incompetence to testify in courts of law. As long as this dumb witness is able to understand the questions being asked to him and gives rational answers to the questions being asked to him or her in the courts of law, that witness becomes a competent witness. That is the general rule. Dumbness does not render a witness incompetent. It makes such witness incapable of understanding. However, this one can come as an exception as long as that dumb witness is not able to understand the questions being asked to him and give rational answers to those questions. That one makes that witness incompetent to give evidence in the courts of law. This is provided for under section 118 of the Evidence Act of Uganda that provides that a witness who is dumb or is unable to speak may give evidence in any other manner in which he or she can make it intelligible as by writing or by signs, meaning that this witness is able to give evidence as long as is able to answer or to understand the questions being asked to him and give back the rational answers to those questions being asked to him. Application of the law, we have the case of Hamisi versus Republic, whereby a witness was already dumb and deaf. But this witness, he was able to communicate to the questions being asked to her, being asked to him, was able to communicate and answer those questions even though he could not speak and hear. So he was taken as competent witness. You should remember the general rule is providing for that under section 117 that every person is competent to give evidence in courts of law as long as that person can be able to understand the questions being asked to him and give back rational answers to those questions being asked to him. Let's dive to competence of the children of tender years are also competent in the courts of law to give evidence. The principle is that very younger children are incompetent to give evidence in the courts of law. Very younger children, that is the principle, of course, that younger children of tender years are incompetent to give evidence in the courts of law. But who is a child of a tender years? According to the case of Kawagei versus Republic, court defined who is a child of tender years. That is that child that is below the age of 14 years. That is the child below. That is the child of tender years. These ones are incompetent to give evidence. How did they become incompetent? How did they become competent witnesses? These children or this child of tender years, they can also be competent witness as long as the child understands the question being asked to him or her and be able to give rational answers towards those questions. A child becomes a competent witness or a good witness. But before the court considering this, the court will call out what we call a voir dire, whereby in a voir dire, they will be testing the capacity of the child, whether this child of tender years can be able to understand the questions being asked to him or her and be able to give rational answers, or whether this child can be able to understand the value of testifying or the repercussions that can happen if at all there is lying or giving wrong evidence in the courts of law. So the judges or the court can go ahead by asking the child that, do you know the repercussions if at all you deceive? If at all the child replies with relevant or rational answers, that child shall be competent witness and shall sworn in the courts of law, and the evidence shall be admitted or shall be taken. However, if the child fails to testify or take an oath, the child of tender years or of tender age fails to take an oath in the courts of law, it means that this type of evidence should be or will be corroborated. So it means that a child of tender years, the principle is that the child of tender years is incompetent to testify in the courts of law. However, if at all that child, if at all they have completed taking what we call the viodaya, when that child is, the court have discovered that this child is competent, is able to understand the question being asked to him or her and give rational answers, of course, that child will be a competent witness. Given that Section 117 provides for general rule that all people, all persons are competent witness in the courts of law. Let's look about the competence of the accomplice. Accomplices are competent witness. The principle or the general rule is that an accomplice is a competent witness against an accused person. That one becomes a competent witness under the understanding or under the provision of Section 132 of the Evidence Act that provides that an accomplice shall be competent witness against an accused person. If at all accomplice is bringing evidence against an accused person, that one becomes a competent witness. Let's go ahead and look about the competence of insane witness. Somebody who is insane, is he competent to give evidence in court? However, when you look about the principle here, it provides that insanity is a ground of incompetence in courts of law. Meaning that somebody who is insane is incompetent to give evidence in the courts of law. However, this will also depend on the discretion of the courts of law. If at all that person who is insane is able to understand the question being asked to him and give back rational answers to the question being asked, that person shall become a competent witness. You have a case here of R versus Hill on insane. A lunatic was an eyewitness of manslaughter. Medical evidence showed that the witness suffered from delusion, but this did not affect his understanding of the ear, or this did not affected his understanding of the oath. So it was held that he was a competent witness. So, given that the principle is that people who are insane, the principle provides that they are incompetent witnesses. However, it will also depend on the discretion of the court. As long as that person can understand the question being asked to him and they have the audacity to reply with rational answers, that person will become a competent witness, according to the case of R versus Hill, where a lunatic was, or an insane Hill, his evidence was accepted in the courts of law. Let's look about competence of spouses. The competence of spouses. The general rule is that a wife or husband of the accused person can be a competent witness, but cannot be compellable. When you talk about compellability of a witness, it means that here the court is forcing you, you are compelled, you are forced to go under the courts of law to give evidence, whether you have consented or you have not consented. That's the meaning of compellability. So when you talk about the competence of the spouses, these people are competent. The person can be competent but not compellable, as we are going to understand it down there. So Spouses are competent witness, but they are not comparable witness. But they can be, for the side of prosecution, there's an exception to this, even though they cannot be comparable. But on the side of prosecution side, a spouse can be a comparable witness. A wife or a husband can be forced to go in court and give evidence and act as a witness, even though there is no consent. He or she can be forced to go in court to give evidence. If at all it's a criminal matter, when it is on the side of the prosecution. I urge you to address your mind on Section 120 of the Evidence Act. So here we have an interesting case of Ara versus Amkeo. The court held that the wife to the accused was a competent witness for the prosecution, even though she appeared to testify without the consent of the husband. It meant that in this case, the wife was competent but was compelled to testify on the side of the prosecution, even if the husband never consented about on that. So this means that with the general rule about the spouses, they are competent but not comparable. But the exception is they have the corridors where they can be compelled to give evidence in instances whereby it can be a criminal matter on the side of the prosecution. You can be taken to testify against your own will. You have even another exception uh, whereby a spouse can also be compelled to a husband or wife of the accused shall be a competent and a comparable witness for the defense. If at all there is a defense, a spouse can be compelled to give evidence. Numbers, I've been talking about comparability. Comparability simply means that comparability, it means that you will be forced to go in court and give evidence, even if you have consented to that or not, the court will force you to go and give evidence. Let's look about this. However, we have an exception to the comparability, whereby comparability is not about forcing somebody to go to the court to give evidence. But we have some instances whereby comparability or other people that are not comparable, whereby for them they are competent witness, but they are not comparable to go in court of law to give evidence. For example, we have people like we have what we call professional privileges. People people like advocates. And the advocates are not supposed to be compelled to go in under courts of law to give evidence. Section 125 of the Evidence Act confers the privilege of the advocate to disclose communication between their clients. These people are not compellable to give evidence in courts of law. We have other people, the judges and magistrates. These ones are not also compellable to give evidence in under courts of law. According to Section 191 of the Evidence Act, judges and magistrates are not compellable, even if they are competent witness, but they are not compellable to give evidence. We have even state privileges. According to Section 122 of the Evidence Act, it provides that no one shall be permitted to give evidence derived from unpublished official records relating to any affairs of the state, except with the permission of superior officers in charge of that. So if you talk about that, You are not allowed to do that. Somebody is not compellable to go and bring evidence. So we have we have others like privilege of the official communication, and many where we see many sections that talk about that, where we see that somebody is a competent witness but is not compellable, cannot be forced to go under courts of law to give evidence. However, this topic of competence and compellability of witness, it's the essence that the general rule in section 117 of the Evidence Act, it providing that all witnesses, all persons, all individuals are competent to give evidence under courts of law, as long as that person can understand the questions being asked to him and give rational answers to those questions. That person becomes a competent witness. And we talk about comparability of witness, whereby we have exception for this. In comparability of witness, whereby you are being forced to go under the courts of law to give evidence, even if you have consented or not. However, you have an exception to this, where other peoples, like the judges, the judges, advocates, magistrates, are not compelled to give evidence. Anyway, thank you for watching. This is Ego Credence, where we share the law and current affairs. Thank you.